Question number 141. A lease from year to year, it shall not be a contract in its nature determinable. That is, it cannot be put an end, it cannot at once be put an end to. So, such a contract can be specifically enforced. So, the correct option shall be A. Question number 142. Such kind of contract requires continuous supervision, which under section 14(1)(d) the law says that the courts do not find it possible to do. So such kind of contract shall not be specifically enforceable. Question number 143. This doctrine is also relates to section 43 TPA, and when we talk about section 13 of the Specific Relief Act, it talks about only about the contract to sell and about the contract to let. So the correct option shall be option C. Question number 144. Before acting under order 8 rule 10 CPC implies that there was no written statement from the side of defendant. So, but still, before pronouncing the judgment in favor of the plaintiff, the court under section 16 clause C of Specific Relief Act has to see that averment was made and there was proof that the plaintiff was willing, has always been ready and willing to perform his part under the contract. So it is a necessary condition to be seen by the court. So the correct option is A. Question number 145. Here if we see that the plaintiff becomes major on 10/10/2008. The cause of action arose on 10/11/2003. The limitation expires on 10/11/2006. But the A becomes major on 10/10/2008. So the limitation shall start running from 10/10/2008 and it shall expire on 10/10/2011. So this suit could have been instituted on 10/10/2011, which was not instituted. 11/10/2011 and 12/10/2011 were holidays. Though they could have been excluded, but then the suit was not filed. They could have been excluded under section 4, but when the suit was not filed on 10/10/2011 itself, the suit shall be barred by limitation. So the option shall be A. Question number 146. Here if we see the cause of action arose on 7/10/2012, but then one of the joint holders was a minor. The law requires that the suit be brought only by all the contemporaneous holders of land jointly. Now when the suit was filed on 15/11/2014, 1 month after the minor holder became major, it shall be within the period of limitation and the suit shall not be liable to be dismissed on the ground of limitation. So the option B shall be the correct option. Question number 147. Here if we see, though X and Y could have challenged the alienation made by the father, but they preferred to wait for the minor son Z to become major, and now they want to file the suit, which is clearly barred by limitation, because it was not required by X and Y, as was in the earlier question, to join Z with them. A suit could have been maintained by X and Y, or X or Y, against the alienation of alienation made by the father. So the suit brought by these X and Y shall be barred by limitation. So the option A shall be correct. Question number 148. Such time spent in good faith in proceeding in not a proper court of jurisdiction shall be excluded by virtue of section 14. So option C shall be the correct option. Question number 149. Section 18(2) specifically provides for the admissibility of oral evidence for proving the date of the acknowledgement. So option A shall be the correct option. Question number 150. Here the facts talk about the continuous breach of contract. So the period of limitation shall start from each and every moment. Uh, so even if in 2010 the floor of the main veranda got damaged and it had the limitation period of 3 years, even then if the suit was brought in the year 2015, it shall not be barred by limitation because it was a case of continuous breach of contract. See section 22 of the Indian Limitation Act. Thank you.